In a legal system that prides itself on order, transparency, and due process, the sudden acceleration of a high-profile lawsuit involving an enormous sum can have far-reaching implications. The mere act of expediting a case of this magnitude can create ripples throughout the judiciary, evoking questions about motive, precedent, and the integrity of institutional structures. The implications of a legal process speeding up, particularly one surrounding a politically charged and financially significant lawsuit, are both dramatic and deeply unsettling. This shift does not happen in a vacuum. It's influenced by underlying pressures, possibly external forces, and a strong current of public attention that places immense scrutiny on the decisions made at every level of the legal hierarchy. In this context, the decision to push forward the timeline of a case involving hundreds of millions of dollars raises eyebrows not simply for the speed, but for the underlying message it sends. Normally, complex legal disputes of this scale require extensive time to gather evidence, consider motions, and ensure that both parties are adequately prepared. The expedited process potentially undermines that delicate balance, calling into question whether all due diligence is being properly observed. It suggests that something, or someone, is compelling the system to abandon its traditional pace and perhaps bypass some of the safeguards that exist to protect fairness. Such sudden acceleration often ignites suspicion, not just from legal professionals, but also from the general public. In a society increasingly aware of institutional flaws and bias, this move is bound to provoke discourse. Is this truly about efficiency, or is there a more calculated intent beneath the surface? Could this be about controlling the narrative, setting a precedent, or ensuring that the case reaches a particular outcome before public sentiment shifts or more information is unearthed? These are valid and powerful questions that begin to emerge when the clock of justice appears to tick unnaturally fast. Moreover, the environment surrounding the case intensifies the stakes. If it involves figures of political prominence or corporations with vast resources and influence, the decision to fast-track proceedings takes on even greater weight. It may create the perception or the reality of a judiciary that bows to pressure or acts in ways designed to protect specific interests. That alone can destabilize public trust in the impartiality of legal rulings. When justice is perceived as something that can be influenced or expedited based on power dynamics, it no longer serves as the neutral ground it is meant to be. The reaction to this abrupt pace also serves as a window into broader systemic concerns. Legal professionals, watchdogs, and informed citizens are likely to interpret such a development as a warning sign. If one case can be hurried through the courts, under suspicious circumstances, what stops others from being manipulated the same way? It chips away at the foundation of equal treatment under the law and sets a dangerous precedent for future litigation, where speed becomes synonymous with strategy rather than necessity. The psychological and emotional toll on everyone involved should not be underestimated either. Those on the receiving end of this expedited process may feel cornered, unprepared, and stripped of the opportunity to fully defend themselves. For them, it might feel like a staged spectacle rather than a legitimate legal proceeding. Meanwhile, observers begin to wonder whether they're witnessing justice or theater, whether the truth is being uncovered or concealed in the rush toward a verdict. Lastly, this kind of development is amplified in the court of public opinion. In today's information-saturated world, the narrative surrounding such an event can easily spiral out of control, leading to conspiracy theories, political finger-pointing, and widespread cynicism. The legal system must therefore not only administer justice, it must also be seen to do so fairly, without undue haste or hidden agenda. Otherwise, it risks undermining its own authority in a time when trust in public institutions is already perilously thin. The notion of a legal authority abandoning their post during the progression of a major lawsuit stirs a volatile mixture of alarm, speculation, and suspicion. When someone deeply embedded in the judicial process abruptly exits the jurisdiction, particularly in the midst of a high-stakes legal confrontation involving massive financial implications and national attention, it sends shockwaves through both legal and public spheres. Such an act disrupts the very framework that upholds accountability and continuity within a justice system that depends on stability and presence. This departure creates a void not just in responsibility, but in perception. It invites a flood of interpretations, some grounded, others speculative, but all centered around the same core concern. Why would a key figure vacate their position at such a critical juncture? The absence raises questions about confidence in the system, the pressures being applied behind closed doors, and what truths might be too heavy to confront within the bounds of legal structure. It leaves observers to wonder if the departure is a symptom of deeper, more systemic cracks that have long been concealed beneath layers of institutional decorum. This kind of move destabilizes proceedings, halting momentum and casting a shadow over the legitimacy of ongoing actions. Any decisions made prior to the departure may be re-examined under a harsher lens, potentially seen as biased, manipulated, or orchestrated to serve interests beyond the law. Furthermore, the process of replacing such a pivotal role is rarely seamless. New appointments must contend with the weight of unresolved decisions, divided public opinion, and the almost impossible task of re-establishing trust in a context that has already become tainted with suspicion. Moreover, this act has psychological consequences that ripple through everyone connected to the case, from plaintiffs and defendants to the legal teams and public observers. It suggests a breach in the ethical or procedural fortitude expected from someone in such a powerful position. Confidence erodes when authority figures retreat, and this erosion fuels public distrust, not only in the individuals involved, but in the very system meant to deliver impartial judgment. On a broader scale, it challenges the sanctity of legal roles. Individuals who step into judicial authority do so with the understanding that they must remain anchored even when the storm intensifies. Their role is not just to interpret and apply the law, but to embody its stability. When that role is abandoned midstream, it creates a cascading effect, potentially jeopardizing other cases, raising concerns about similar vulnerabilities, and inviting broader criticism of the institution's resilience. Furthermore, such an exit often leaves behind a trail of unanswered questions. Was there undue influence? Were there threats, political, legal, or personal, that made the environment untenable? Or was the pressure of presiding over such a high-profile case too much for one person to endure? The lack of clarity opens the door for countless narratives, many of which are shaped by ideological bias or fear rather than evidence. In a media landscape hungry for sensationalism, such ambiguity becomes fertile ground for misinformation and polarization. Another significant dimension is the impact on future cases. Legal actors, judges, attorneys, and even jurors may look at this incident as a cautionary tale. It might alter their willingness to involve themselves in politically explosive or high-dollar litigation. The perceived instability could deter qualified individuals from stepping into roles where the stakes are no longer just legal, but existential. This chilling effect weakens the pool of impartial, brave leadership that the system depends on to function. Lastly, the symbolic ramifications are immense. Authority in a court setting is not just about the robe or the bench. It's about the perception of unyielding fairness, steadiness, and courage under pressure. When that image is fractured, the consequences are not confined to a single case. They echo into public consciousness, reshaping how people interact with, believe in, and respect the law. This departure then becomes more than just a personal decision. It becomes a moment of reckoning for a system already walking a tightrope. When a legal case is thrust into the national spotlight and tied to staggering financial stakes, the atmosphere around it begins to change. It no longer exists merely as a dispute between parties in a courtroom. It transforms into a public spectacle, an unfolding drama that captures attention far beyond the legal community. In such circumstances, the players involved often find themselves operating within dual arenas, the judicial process and the realm of public opinion. These cases become lightning rods, attracting commentary, political narratives, and media distortions that can deeply impact the integrity of the proceedings. As the lawsuit accelerates and headlines multiply, the motivations of everyone involved come under scrutiny. Every action is viewed through a lens shaped by ideology, suspicion, or financial interest. The size of the lawsuit alone triggers questions. Why now? Who benefits? What is being revealed or concealed through the pursuit of such an enormous, claim? In high-dollar cases, especially those connected to politically charged figures or institutions, it becomes difficult to separate the facts from the storylines being crafted around them. This level of exposure alters how justice is pursued. The process becomes weighted with external expectations, some calling for swift punishment, others demanding the case be dismissed as theatrics. Legal strategy begins to adapt not only to the courtroom's requirements, but also to the pressure of shaping public perception. Lawyers on either side may find themselves making decisions not only based on legal merits, but on how those decisions will be portrayed in headlines, social media posts, and televised debates. This environment breeds distortion. When the media focuses on a case of this scale, key details are often oversimplified or sensationalized. Legal nuance is flattened into binary choices: guilt or innocence, hero or villain, win or lose. The complexity of the law gets lost in the noise, and the public's understanding of the actual proceedings becomes shaped more by narratives than by facts. This is dangerous in any democracy, where the rule of law relies not only on impartial procedures, but on a population that trusts in its fairness and legitimacy. Another key issue is the timing. When a case appears to move more rapidly than expected, or when procedural decisions are made unusually fast, questions arise about whether due process is being sacrificed for political convenience or media-driven urgency. The speed at which a case develops can dramatically affect the fairness of outcomes, particularly when discovery, witness preparation, and the judicial review of motions are all critical to ensuring justice. Acceleration in such a climate can look less like efficiency and more like maneuvering, especially when key elements of the case intersect with ongoing political debates or broader cultural issues. Public reaction plays a major role in shaping the emotional context around the case. Some people may view the suit as a long overdue reckoning, while others see it as an orchestrated attack or a distraction from other events. This polarization reduces the space for calm, reasoned analysis, and it can pressure legal actors into decisions that satisfy one side of the divide rather than uphold objective legal principles. Every document filed, every hearing scheduled, becomes a data point in a larger narrative war unfolding across newsrooms and digital platforms. This backdrop also impacts the individuals involved, not just the institutions. Plaintiffs and defendants alike are subject to public judgment, often facing personal threats, professional consequences, and emotional strain beyond what a normal legal dispute would involve. The heightened visibility can influence witnesses, discourage transparency, and create an environment where fear or bias may enter the equation, despite the best efforts of the court to keep proceedings fair and focused. The financial size of the lawsuit adds yet another layer of tension. The sheer number tied to the case sparks curiosity, outrage, or disbelief, depending on one's perspective. It makes the case too large to ignore, too tempting to exploit, and too easy to politicize. It also raises the stakes to a level where compromise becomes difficult, as the perception of victory or loss has implications far beyond the courtroom, including elections, reputations, and the credibility of entire movements. The magnitude of the money involved transforms the suit into a symbol, and symbols rarely invite neutral discussion. In the end, what was once a legal proceeding becomes a battlefield for influence. The pursuit of truth, already difficult under the best of circumstances, must now compete with the pursuit of narrative dominance. And in that competition, the law risks being overshadowed by the louder, faster-moving machinery of public opinion. In moments of extreme public tension surrounding major legal events, perception can become more powerful than reality. The way people interpret a situation often matters just as much, if not more, than the actual facts. When a high-profile lawsuit, involving massive financial stakes and political undertones, begins to dominate the conversation, it doesn't just exist as a legal matter, it morphs into a cultural phenomenon. In this space, symbolism, emotion, and bias take on outsized roles, and institutions are judged not solely on what they do, but on how they appear to the outside world. At the heart of this phenomenon is the way the public processes information. In an age dominated by social media, fast news cycles, and deepening ideological divides, the truth becomes a moving target. A single detail, whether accurate or not, can spark outrage, suspicion, or solidarity depending on who's receiving it and what they already believe. The lawsuit becomes more than a legal matter. It's interpreted as a representation of something larger, such as corruption, reform, control, or resistance. This symbolism drives emotional responses, making it harder for calm, rational engagement with the facts. When institutional figures are seen retreating, or processes appear accelerated without clear explanation, people begin to question what's happening behind the scenes. Transparency is no longer just a virtue, it becomes a necessity. Without it, gaps in the story are filled with speculation. Theories form rapidly, often with little evidence, yet they spread quickly through networks of like-minded individuals, cementing beliefs that become resistant to correction. These beliefs become part of the narrative ecosystem surrounding the case, influencing everything from media coverage to political talking points and grassroots activism. In such a charged environment, the credibility of legal institutions is placed under an intense microscope. Even the perception of unfairness, bias, or weakness can be more damaging than the actual existence of those flaws. Once people lose faith in the system's ability to uphold justice impartially, it becomes extremely difficult to rebuild that trust. Every new action, whether procedural or substantive, is interpreted in light of the growing suspicion. People begin looking for confirmation of what they already fear, that power is not equally distributed, that justice is not blind, and that outcomes are determined by influence rather than integrity. This erosion of trust spreads quickly. It doesn't just affect the case at hand, it spills over into how people view other institutions as well. The media, elected officials, law enforcement, and regulatory bodies all become part of the larger conversation about whether the system works and for whom it works. These discussions are rarely neutral. They are emotional, often fueled by long-standing grievances and cultural narratives that position certain groups as victims of a rigged game. The lawsuit becomes a flashpoint in a much broader conflict over power, truth, and legitimacy. The psychological toll of this is considerable. For those who already feel marginalized or disillusioned, the case becomes more evidence that justice is out of reach. For others who view the lawsuit as a threat to the status quo, it may represent an existential battle for control. These polarized perspectives feed into a cycle of distrust and retaliation, making dialogue and consensus nearly impossible. What began as a legal dispute now threatens to deepen social divides, destabilize communities, and reinforce the belief that the system cannot be trusted. In this climate, even the most neutral action can appear suspicious. A delay in proceedings is seen as a cover-up. A swift decision is interpreted as coercion. The appointment of a new official or the reassignment of responsibilities is analyzed for hidden motives. There is no longer room for ordinary procedural adjustments because everything is viewed as part of a grander narrative. Legal professionals are forced to navigate not only the written law, but also the invisible pressures of public expectation, political ramifications, and media framing. The broader consequence is a weakening of civic confidence. When people feel they can no longer rely on institutions to operate fairly, they begin to seek alternative forms of justice or disengage entirely. The result is a fragmented public, more prone to conflict than cooperation, and more interested in winning narratives than understanding truths. The power of perception, once unleashed, becomes nearly impossible to contain. It reshapes how people vote, protest, donate, and organize. And in that shift, the lawsuit itself may become less important than the story it has come to represent. As the dust settles around such a high-stakes and emotionally charged legal saga, one truth remains unavoidable. Moments like these test the strength, integrity, and resilience of our institutions. They reveal not only how justice is pursued within the confines of courtrooms, but also how it is perceived and debated in the public square. The repercussions extend well beyond a single lawsuit, influencing trust in the broader legal system, confidence in governance, and the collective sense of fairness that holds a society together. Legal systems are designed to operate with structure, impartiality, and a deep commitment to due process. But when a case becomes entangled with massive sums of money, political tensions, media scrutiny, and public emotion, that system is pushed to its limits. Even a minor misstep, or the appearance of one, can cascade into public backlash and institutional doubt. In such a climate, perception becomes just as powerful as fact, and narratives often carry more weight than verdicts. People begin to look not only at what was decided, but why it was decided, and who stood to benefit or suffer from that outcome. The pressures placed on those within the judicial system grow exponentially in these conditions. Every move is analyzed, politicized, and potentially weaponized. For those tasked with ensuring fair proceedings, the burden becomes not only legal, but symbolic. They are expected to represent strength, clarity, and neutrality in an environment that may offer them none of those protections in return. The consequences of miscommunication, delayed action, or perceived bias are no longer confined to one case. They ripple outward into a deeply polarized public. Yet even in the face of public discontent or high-profile disruptions, the principles of justice must hold firm. The legal system is one of the last remaining institutions where truth, evidence, and reasoning still have the potential to prevail over noise and speculation. That promise is fragile but vital. It requires active defense, not just from legal professionals, but from citizens who understand the importance of due process, even when the outcomes are inconvenient or unpopular. These events also present an opportunity for reflection and reform. Transparency, communication, and accountability are not optional when public faith is at stake. They are essential tools for preserving legitimacy. Legal institutions must be willing to confront public skepticism with honesty, not defensiveness. They must find ways to demonstrate that justice is not only being done, but being done fairly, consistently, and without favor. In the end, what matters most is not the sensational headlines or the immediate reactions, but the long-term impact on how justice is understood and upheld. The test of a legal system is not whether it avoids controversy, but how it withstands it. If it can remain principled in the face of pressure, maintain fairness in the face of fear, and restore trust in the face of uncertainty, then it will not only survive such trials, it will emerge stronger and more deserving of